Good morning, everyone. My name is Jennifer Torgerson. I am the sales manager here at Birch Hill. We'd like to welcome you all to joining us today with this Estate Planning 101 webinar. We will be welcoming Jennifer Rivett. Attorney Rivett is with Divine, Millimet, and Branch here in Manchester, and she works with local families and individuals on their estate planning needs. So welcome, Jennifer. And in order to get started, I think we'll start with some housekeeping notes briefly. You are on mute, but we do welcome questions. Certainly there is a Q&A screen down at the bottom, and we will address the questions at the end of the program. Your suggestions on how to make improvements with these programs are highly desirable, so please feel free to make suggestions for future programs as well. Other topics that you haven't seen, we would welcome. And the presentation is being recorded, so you will receive a link within a few days, and you can certainly watch it again or share it as needed. I just want to start with a couple of screens about the Riverwoods Group and Birch Hill and CCRCs in general, real quick. The Riverwoods Group is the parent company to 3 different campuses. Birch Hill became a Riverwoods Group community in 2016. Exeter from the early 90s on with 3 different communities in Exeter, New Hampshire, and Riverwoods Durham that opened in 2019. Then we have SPE, and that is what we call someplace else. The Riverwoods Group intends to slowly expand what they do so well over time and add a campus and increase what they do so well. So just very quickly, what is a CCRC? It is a continuing care retirement community. The contracts are generally regulated by the state because we are an insurance product. Financial performance is reported to the state annually, and you are prepaying and insuring for potential care in the future, assisted living, nursing care needs. A portion of the entrance fee and monthly fees are tax deductible, but a CCRC is also a lifestyle choice. You enter when you're independent. You're free from home maintenance chores, and you can choose from transportation and dining options, activities, programs, lectures, concerts, classes, you name it. You have increased social options, and a CCRC allows you to stay in control of your life. A CCRC answers the question to the cost of future care, quality of future care, availability, and location where you will live in the future. A continuing care retirement community is a place where you enter when you're independent, able to live safely on your own. The minimum age is generally 62, and we provide at least 3 levels of care: independent living, assisted living, and nursing care. Some also have memory support, as Birch Hill does. Residents can typically transition between the 3 levels of care freely as needed, as their health needs dictate. There are services and amenities provided at every level of care. And again, typically 2 fees, entrance and monthly fees, a portion of which are tax deductible. Meet new friends, have time to pursue new interests, become more active as you age. And typically a continuing care retirement community offers benevolence should you outlive your assets at no fault of your own. About Birch Hill in particular, we have a long-standing history, almost 140 years in the Manchester area with the Women's Aid and Relief Society. We've had a few transitions over the years: Pearl Manor, Hillcrest Terrace, Birch Hill Terrace, and Birch Hill as of 2016. We became Manchester's only CCRC in 2009. And then again in 2016, we joined the Riverwoods family, and we are the only Type B contract in the Riverwoods Group where you don't pay for care you don't need. We recently completed interior renovations, $14 million of renovations in independent living. And over the next 2 years, we will be renovating the exterior of the community and parts of the healthcare side of the community. We do have availability currently. We have a very small number of 2-bedroom floor plans, and we do have some 1-bedroom apartments available. And in case you're not familiar, we are located almost halfway between Manchester and Concord, actually, up on a hill overlooking Manchester. It's just a little hidden gem of a community with a large nature conservancy right across the street. Birch Hill is known for having an innovative 70% refundable flexible contract in New England. So you can use your 70% refund to pay for your healthcare costs if you move permanently to assisted living or higher. You can use those funds for the future. It's more affordable. You have lower entrance fees and monthly fees than in a Type A community, and it's a great value for couples. Couples get a great deal in a Type B CCRC like Birch Hill. It provides greater flexibility of cash flow throughout your lifetime. You can use your long-term care insurance here. Long-term care works very well at Birch Hill. We can bill your long-term care company and they reimburse you for whatever your policy covers. And again, you can access your money during your lifetime, or you have the option of leaving it to your estate. It's your choice. So Birch Hill is a predictable, flexible, great value in long-term care. What about COVID? Actually, we're very well set up for COVID. We, as a CCRC, are well equipped. We have professional nursing staff on duty 24/7, housekeeping staff. We have access to PPE, sanitizing stations, disinfecting all touch points in the building all day, every day, testing and vaccination clinics. We're aggressive about safety. You still have greater access to community. Even during a pandemic, you can get out and walk the 29-acre campus, see your neighbors at a distance, and get deliveries of meals, mail, packages, groceries, prescriptions. And of course, we have a wellness clinic that is a free service with our nurse practitioner in independent living. So I just want to introduce Jen Rivett. Attorney Rivett is going to talk about estate planning, which is a wonderful opportunity for us because we do have many applicants that come in with trusts and don't always understand how the different trusts work. So thank you, Jen.
Thank you, Jen. Good morning, everybody. I'm pleased to be here and hope I can shed some light on what I think is a pretty important aspect of life, which is estate planning. And what an estate plan can accomplish, what are some of the fundamental pieces to an estate plan, and why it's important at the end of the day. I think a good estate plan truly is invaluable at all stages of life. An estate plan is really intended to do a couple of different things. First of all, we want to protect your family. Oftentimes when clients come in, they want to be sure that the folks who are important to them are going to be cared for when they're no longer with us. So often we want to make sure a spouse or a partner is going to be taken care of. We might want to plan for children and grandchildren, and actually I've been doing some planning for even great-grandchildren. Plan for other relatives. Maybe we have siblings or nieces and nephews, cousins. We want to benefit from our estate in some way. And at the end of the day, by simplifying your settlement of your affairs, that will ultimately protect your family. An estate plan is going to ensure that your wishes are carried out rather than directed by the laws of what we call intestacy. So each state has a law that will tell us where assets should go in the event that somebody passes away without a will or a trust. And it's surprising to a lot of folks how these laws might work. And generally speaking, the assets will pass to those who are close to you within your family, but that's not always where you want those assets to go. And another thing that surprises a lot of clients is that the spouse may not actually inherit everything, particularly here in New Hampshire. If a spouse and children survive you, the spouse and children may actually divide your estate. And again, that may not be ultimately what you wanted to have happen. A non-spouse partner will not receive anything under our intestacy laws. And if there is no spouse surviving, the children ultimately will divide that intestate estate equally. But again, that may not be consistent with your wishes. And if you had any charitable intentions or other family members that you wanted to benefit, relying on our default intestacy law is not going to get you there. So again, an estate plan is going to help us carry out those wishes. A good estate plan is also ultimately going to save time and money. Some plans incorporate federal and state estate tax planning to minimize the estate taxes that might be due upon the first death and maximize what can be passed to your next generation. We're going to talk further about taxes in general at our next session in a couple of days, so please come back for that. Probate is another thing that can be addressed in estate planning. Some estate planning allows us to bypass the probate process altogether, which can save on administrative costs and allow us to eliminate delays as far as how to settle estates. Probate in general can take some time. In New Hampshire, it can take anywhere from about 8 to 12 months, even the most routine of cases. So, those waiting periods can sometimes be costly. They can become frustrating. There are court filing fees that are involved with some probates. So again, the probate process, while not horrendous, is certainly something to consider avoiding. And again, a good estate plan and an estate planner is going to talk to you about that. A good estate plan is going to reduce the burden on your family, as we had talked about just earlier. How do I protect my family? One way to do that is to reduce the overall burden. By putting an estate plan in place, you're going to be able to name those people who you want to handle certain aspects of your life and incapacity and estate settlement. So naming a person to serve as the fiduciary to pay your debts, handle any estate settlement matters, naming a person who can make healthcare decisions for you, in the event that you're no longer able to do so. It ultimately eliminates, hopefully, a lot of questions as to who should be doing what. It allows those people to be able to step into those roles quite easily. And it also, again, hopefully will help to maintain family harmony by eliminating some of those questions. So all of this planning really does have an invaluable benefit to you and your family. So what is an estate plan? Simply put, it's really a series of documents that are going to outline who should be handling your affairs, who should be receiving your assets, under what conditions, what assets should be passing where. Sometimes we will even put in why certain things are occurring, and certainly how those assets should pass. But ultimately, it's really just a series of documents that an attorney will draft for you with input from you, giving you advice, given your specific situation. And those situations can change over time, right? So you might be moving from one state to another. Your family dynamics may have changed. You may have additions, either children or grandchildren or great-grandchildren. Perhaps you have purchased real estate in another state and you're going to go back and forth between two states. Or perhaps you started a business, you're on your next phase of life and have started that business or passion project. All of those situations and changes really may be impacted by your estate plan or may impact your estate plan. So a good estate plan is not only going to be something that's going to serve you now, it also needs to be and should be updated in the future as situations change. So what's a will? And this is really something that we often think about as a traditional estate planning document. So a will is really a document that's going to address how do we distribute assets that are in a person's sole name when they pass away. The instructions are carried out by a person you choose, known as the executor. And the executor ultimately will submit the will to the probate court after someone has passed away. And they are under the guidance and supervision of the probate court. In New Hampshire, we have what's called the New Hampshire Circuit Court Probate Division. So that is where all of the probate administration will occur. And this is something I hear quite often. A will itself does not avoid probate. So I do have a lot of clients who will come in and ask me, is there, we have a will, why would we have had to go through the probate process? The will actually governs the probate process. It's not a document that's going to allow us to avoid the probate process. A trust is something that may actually help us avoid the probate process. And a trust, oftentimes you will see these called living trusts or revocable trusts. But ultimately, a trust is, again, another document. We go through a lot of paper, but it's another document that gives us instructions about how your assets and property should be managed during your lifetime. That can be really helpful in the event of incapacity, or if you start to decline and need assistance handling your financial affairs, assets, and property. A trustee who you've chosen can step in and really help through that incapacity period. A trust is also an opportunity to leave instructions as to how your property should be distributed after you pass away. Again, a trustee, similar to an executor, but a trustee is someone who can and should carry out those instructions that you've left in the trust, and they have a fiduciary duty to do that. Assets can be placed into a trust during your lifetime, and we'll talk a little bit about that later, but often we see where folks have gone through the time and expense to set up a revocable trust, and it turns out it was never funded. So it's a beautiful, document. It's very long and says a lot of things, but there are no assets in that trust when the grantor, the person who set it up, passed away. We're still going to go through the probate process to get everything into trust and then carry out the terms of the trust. So really, assets, if somebody has set up a revocable trust, part of that planning process should be sure that your trust is actually funded and those assets are put into trust. Beneficiary designations can name your trust as a beneficiary. So for example, if you have a life insurance policy, or in some cases IRAs or other accounts or assets that have beneficiary designations, a trust can be a beneficiary. There are, again, complications with respect to naming an IRA as a beneficiary of a trust. The laws concerning those have changed a bit. So you really do need to get some good advice from counsel as to what makes the most sense with respect to what assets should pass through the trust, what assets should be titled in the name of the trust, and or the trust being designated as a beneficiary. As I mentioned before, a trust is a tool that we use to avoid the probate process. If the assets that you own at death are owned by your trust, then those assets pass outside of that probate court process. It's an agreement that you've entered into. It's governed by state law, and the trust and the trustee will carry out the terms of that trust on your behalf. What's nice about that is you can avoid that probate process because you don't own the assets solely when you pass away. A trust allows us to, similar to a will, allows us to divide assets differently among different beneficiaries. So perhaps you have multiple children, but you want to treat one differently than the other for whatever reason. Perhaps one is receiving certain benefits and can't inherit money outright. We might want to plan for those beneficiaries in that way. Perhaps you have a beneficiary who just is really not good with money management. We don't want them to inherit everything outright. We can utilize a trust, an ongoing trust, for the benefit of a beneficiary. Maybe we want to divide assets between children and grandchildren, or perhaps there is an asset that we want to have passed to one child and other assets passed to another. I've seen this with real estate or business interests sometimes, that one beneficiary should inherit a parcel of real estate in kind, for example, or is involved in a business, and those business interests should pass to that one beneficiary. And then the other beneficiary or beneficiaries will receive equalizing distributions of other assets. So you can outline all of that in your trust. As I mentioned, you might have property that's going to remain in an ongoing trust for the benefit of a beneficiary. Maybe there are specific purposes that you want to be sure those funds are used for. Education is a big one right now for grandchildren and even children. And there might be federal or state estate tax planning that we should take advantage of, and using a trust is a good tool to be able to, like I said before, either minimize estate taxes and or maximize what is passed to the next generation. A revocable trust, by definition, is revocable. And then what that means is that you can cancel at any time, or make any changes over time. And that's really important from a flexibility standpoint. The creator, or the person who set up the trust, known as the grantor, generally has complete control over all of those assets and terms while you are alive and while you are competent. You, the person setting up the trust, can select your trustees, and those are the people who will administer the trust and carry out the terms of the trust when either you are no longer able to do so because you are incapacitated, or after you've passed away. And as I mentioned before, you can direct where the property goes at death. It might pass outright to your beneficiaries and the trust terminates at that point, but there might be a reason that we want to have the trust continue over years or even generations. And certain states allow for what we call dynasty trust, or trust that really can be carried out for multiple generations. So if you have a trust, are you done? And as I mentioned before, you actually, the trust itself and putting all of these terms and conditions into place takes some time, and it's really important to do that, but you also need to fund that trust. And what I mean by that is putting assets into the name of the trust, either retitling bank accounts, brokerage accounts, preparing a deed to transfer real estate into your trust, naming the trust as a life insurance beneficiary, perhaps as the beneficiary of an IRA. And the trust can be the recipient of an entry fee refund, like a CCRC entrance fee here at Birch Hill, for example. If your trust is funded during a lifetime, it does avoid probate. We also have these irrevocable trusts, and I get asked quite a bit about what is an irrevocable trust. Unlike a revocable trust, it is something that it cannot be changed, again, by definition. It is irrevocable. Once it's set up, it cannot be changed. The terms can't be changed, and the assets that are in trust stay in there. The benefit to an irrevocable trust is it can avoid having those assets included in your taxable estate for estate tax purposes, either federal or state. So it can be helpful for families and folks who have significant assets that they want removed from that taxable calculation. It can also be used for Medicaid planning purposes. So we see irrevocable trusts that might move assets off of the table, so to speak, to allow somebody to qualify for benefits such as Medicaid. There are really strict rules about Medicaid planning. You might have heard of a 5-year look back period. There are just a variety of different hurdles and terms and conditions that these irrevocable trusts for Medicaid planning purposes need to meet. That is well beyond the scope of today. And if you are looking at any sort of irrevocable trust, whether for estate tax planning purposes or Medicaid planning purposes, or really for any reason, you really want to speak to a qualified estate planner to be able to understand what these trusts can and cannot do. Generally speaking, an irrevocable trust, the whole idea is that you're going to take assets out of your control, and you're no longer owning the property, you no longer control that property, and you no longer benefit from that property. So it's a big deal, and you really need to get good advice before you tackle an irrevocable trust. And powers of attorney, very briefly, are documents that are solely for incapacity planning. A durable power of attorney or a durable general power of attorney allows an agent who you name to make financial decisions for you. And the term durable is really important because that is what allows the agent to be able to continue to act on your behalf if you are incapacitated. There can be powers of attorney that have limits, so it may be one that does not carry forward when somebody is incapacitated, or it might be for a specific transaction or purpose. But we want to be sure that, if it is intended for incapacity planning, that it is a durable power of attorney. Some powers of attorney for financial matters will have what we call springing language that only take effect when you become incapacitated. And there is typically a triggering event that will tell us when the agent has the authority to step in and handle matters on your behalf. There are also powers of attorney for health and medical matters. Certain states call them different things. Here in New Hampshire, they are called an advance directive. In Massachusetts, they are called healthcare proxies. Essentially the same idea, though, where you name an agent who's going to be making healthcare and medical care decisions for you if you are truly incapacitated. And oftentimes these documents will include directions with specific wishes about your end of life care as well. So if you have an estate plan in place, kudos to you. As I mentioned before, they are flexible and should be updated over time, or at least reviewed over time. And oftentimes those reviews will result in some updates because there might be changes in tax laws that will impact you, either federal or state tax laws. There might be changes in the state tax laws that govern estate and trust administration. Sometimes we're able to simplify some of the terms that we included in our older estate planning documents. Sometimes we need to incorporate new terms into those documents. There might be a change in circumstances. I always tell my clients any major life event, and I define that as a birth, a death, an inheritance, you move to a different state, you start a business, any of those changes in your life might result in an update to your estate plan, or at least that might be advisable. You should always, if you have a trust, confirm that it is truly funded. Again, it doesn't do you much good if the assets aren't in the trust. And review who you choose to serve in different roles. Trustee and fiduciary selection is so important. And sometimes we'll choose somebody who would be great in a certain role, but 20 years later, we look at that document and say, you know what, they're really not the best choice for a trustee. Perhaps they have moved or, are incapacitated themselves or have passed away, or relationships have changed. And maybe that person you trusted to make certain decisions about finances or healthcare just is not that person any longer. So you'd want to update those documents to reflect that change. I always, again, advise my clients to keep people in touch with one another. You may not have to disclose your entire plan, but let someone close to you know that you've done this, you've gone through this exercise, and keep your advisors and family members in touch with one another. Your estate planning attorney, just from a selfish standpoint, is very important. So is your financial planner. Your accountant might have some input into your estate plan and should be involved and at least know if you've updated anything. Your insurance professional, the contact at your residence. So if you move into a CCRC or assisted living, making sure that the folks there know who your points of contact are. Your family members, perhaps there's one point of contact within your family, or the person you're naming to handle financial and or healthcare matters should know that you have a plan in place. And if you've updated it, know that there have been changes made. And those might be family members who are named in your documents. They may not be family members who are named in your documents. So keeping those folks that you choose up to date as to what it is that you've put into place and any changes that you've made. So what have you learned today in this very short and sweet presentation, hopefully? Estate planning puts you in the control of the process. You get to control who's receiving what, who's in charge of your affairs if you can't handle them yourself, where your assets should go. It also can relieve the burden on your family, simplifying the administration of your estate, eliminating some questions, and hopefully maintaining family harmony. And really all parts of your estate plan need to work together. So again, if you set up a trust, be sure that it's funded. Be sure that your advisors know what you've put into place so they can help you with that. Happy to take questions. I know that we have a Q&A option here. And again, my contact information is here. So if you think of something after this presentation, please feel free to reach out and ask. Thanks.
Thank you so much, Jen. That's great information. We do have a couple of questions here. The first being, can you make your own will?
That's a good question. You can. So really, like I said, a will names who is your executor. So you want to be sure that you've chosen somebody properly, and where your assets should go. It is governed by state law, and each state has pretty clear instructions as to how a will can be executed so that it's valid. So you can. I would advise that you get advice from a professional, though, to make sure that the will that you put in place is drafted properly and executed properly. I just had a circumstance where somebody had brought a will to me. It listed out beautifully what their wishes were, but it was not executed properly, and the court is not going to accept that will as a valid will. So unfortunately, what this individual wanted to have happen is not going to happen under our intestacy laws. So if you're able to at least map out where you want your assets to go, and then have somebody licensed in your state who's an estate planner, be able to just review that and make sure that it's executed properly. That will serve you well in the long run. It's a great question.
And what about making your own trust?
So same thing, right? Having somebody advise you is always, I think, and I know it sounds self-serving, right? But I think it's well worth having, a professional review those documents with you, again, to be sure that they are valid, particularly if you have any complex family situations, or if there are any concerns about whether or not, somebody might come back and challenge what you've done or question what you've done. Having that professional advice is going to be really helpful. That being said, I know that there are programs out there, like Quick and Will, or I forget all the different programs that kind of walk you through that process. So I guess the cautionary tale is you can do it, but at the end of the day, you want to be sure that you're covering all of your bases and that your wishes are truly going to be carried out if when you pass away, or if you're unable to make any changes to those documents in the future.
Can you speak to what problems may occur when an executor lives out of state?
Oh, yeah. So we have a lot of those here in New Hampshire. It's a lot easier now. I can speak to a couple of the states that I'm licensed in. I practice primarily in New Hampshire. We can have an executor who's out of state. Very rarely in our routine probates do the executors actually need to appear in court. And nowadays with COVID, there's really no court hearings occurring unless they are emergency type of hearings, and even those often are via Zoom or teleconference. So there's no restriction that your executor has to be in the state where you're living when you pass away. The probate court is going to require someone within the state where the probate is being opened to be able to accept service or appear on behalf of the executor if need be. So even though your executor may be out of state, we can do a lot via email, mail. A lot of the states now have e-filing. So that's really broken down a lot of the burdens where we had an executor out of state. In the event, though, that you do have somebody out of state, you're still going to need an agent here. Sometimes it's the attorney assisting with the probate. Sometimes it's, some family friend or another family member who can accept service in the event that the court needs to serve anyone in the probate administration. But it's not a restriction that you should be able to name somebody who's out of state as your executor or your trustee.
We have some great feedback. Best presentation of this type I've heard from someone down in the South. So thank you.
Oh, wonderful.
And another question, generally, what might be the cost to set up a proper estate and trust documents? And thank you so much for all your explanations, and your help is much appreciated by those attending.
Oh, I appreciate that. Thank you. Yeah, so a general cost, it really depends. But I think if you are engaging counsel, that is always a good question to ask up front. A lot of attorneys bill by the hour. Some will have a flat fee type of schedule, but it's an excellent question to ask. And it's, I think, money well spent. I've seen situations where the plan was not put into place, and oftentimes it's a lot more expensive to try and fix things on the back end or deal with complicated estates without a plan. So certainly worth investing in. And I appreciate everybody's time. Thank you.
Thank you, Jen. I just want to take one moment to remind everybody, we do have another session called The Toll of Taxes with Jen Rivett on Thursday, and that's also at 10 o'clock. You can sign up on our website if you haven't already. In addition, we've got one next Tuesday, the 16th, avoiding probate. So more detail from what she is helping us with today. Any other questions? Please feel free to check our website, birchhillrc.org, and sign up for future events. And again, Jen, thank you so much for your expertise. We truly appreciate you attending today, and all of you out there who have joined us, thank you.
Thank you. Be well.
Bye-bye.